For more information on these popular seminars, call 734-327-5030 or visit www.psychlaw.net. Who is an expert?
In Daubert versus Merrill Dow, the United States Supreme Court said, for all federal courts and for the 26 or 27 states that have now moved to a Daubert standard, that the trial judge must ensure that any and all scientific testimony or evidence admitted is not only relevant but reliable. Now that's must, not may, not should, not oughta, not gee to be nice. Must ensure. One of the things that we're trying to teach, in addition to the use of scientific treatises and the scientific literature, in basic cross-examination strategy is that you want to remember that you're the dog and the witness is the tail. The importance of many of these cross-examination scripts and question sets are to get you something to argue to the trier of fact. If you can get a grudging admission, oh, okay, or well, I guess so, or that's what the literature says, boom, you got it. You can argue that to the trier of fact. In Daubert, the Supreme Court said that the trial court is a gatekeeper, and they use this specifically for the purposes of determining the validity and reliability of scientific evidence. The gatekeeper who must make a preliminary assessment as to whether the reasoning and methodology of the pro-offered testimony is scientifically valid. Key point, scientific validity. The trial court must ensure that the pro-offered testimony is relevant and reliable with a focus solely on principles and methodology. Scientific methodology, said the court, means generating hypotheses and testing them to see if they can be falsified. Scientific knowledge is that which is derived from the empiricism of the scientific method. More key concepts here. Scientific method, empiricism, validity, reliability. Experts, said the Supreme Court, must be grounded in the methods and procedures of science. Experts must know and base their opinions reliably on the datum of their discipline. Kumho was the tombstone for junk science in the courtroom. Some key Kumho-Tyre concepts. The trial court must have considerable leeway in deciding whether the proposed testimony and the proposed expert is reliable. The trial court must determine both the validity of the expert's qualifications and the reliability of the proposed testimony. So you can see there's 4 criteria right in those 2 sentences. If we read Daubert and Kumho-Tyre together, it makes it clear that the trial judge is now required to independently evaluate the reasonableness of the expert's reliance on his or her data and the data underlying the expert's opinion. So they must look at the data. These are preconditions to admissibility under Rule 702. Now this just isn't the old voir dire criteria. This has to do with a more extensive look at the expert's qualifications. The key issues here that we're stressing are evidentiary reliability and evidentiary validity. What is this concept, reliability? Well, essentially, reliability means conclusions that deal with replicability and consensus. Validity, what does this concept mean? Validity essentially is more complicated than reliability. Validity means, are we getting what we think we're getting?